Listen, if you're studying environmental law, you already know that just memorizing the bare acts, that completely won't cut it. To actually master the subject and honestly to secure those top marks, you've got to grasp the deep structural hierarchy and the real-world procedural mechanics. So today, in this explainer, we're going to break down the Water Act, the Air Act, and the Environment Protection Act and figure out exactly how they operate out there in the field.
Here is our roadmap. First, the overarching framework. 2, the core legislative definitions. 3, procedural mechanics and enforcement. 4, landmark judgments. And finally, we're going to synthesize the whole shebang with a highly realistic hypothetical scenario.
All right, let's jump into Section 1, the Module 3 Roadmap, and how to properly structure your exam answers. Moving right along to Section 2, the legislative frameworks, focusing on those core sections that examiners absolutely love.
Okay, pinning liability for pollution always starts with one crucial step: correctly identifying the occupier. Basically, this is the person who has ultimate control over the factory or the premises. You see, regulatory boards, they don't just sue some faceless abstract company. They go right after the occupier. So if a hazard occurs, this is the specific individual legally on the hook.
Next up is trade effluent. And guys, precision here is literally everything. Under the Water Act, this specifically means liquid, gas, or solid waste released from industries. It deliberately excludes household sewage, so leave the residential toilets out of it. If a manufacturing plant is dumping chemicals, you must use the legal term trade effluent in your answer, not just a generic word like pollution.
Now, when we talk about jurisdiction, think of the central government as acting like this massive, overarching umbrella. Under the Environment Protection Act of 1986, they set the nationwide standards and fill in the gaps left by the older laws. But out on the ground, under the Water Act, it's the State Pollution Control Boards, the SPCBs, that handle the localized enforcement. They are the boots on the ground, granting operational consent and running the day-to-day inspections.
To really get how the State Pollution Control Board operates, you have to memorize their statutory powers. Section 20 of the Water Act, that lets them demand information on water usage. Section 23 grants them the power of entry to physically inspect records. And crucially, Section 33A, along with its equivalent, 31A in the Air Act, gives them the massive power to issue binding directions. And yes, that absolutely includes the power to force an industry to completely shut down.
Okay, Section 3, Procedural Mechanics and Enforcement. Basically, the how.
Listen, examiners absolutely love testing Section 21 of the Water Act, which covers the power to take samples. Because here's the catch. If these 4 specific procedural steps for sample collection are not strictly followed, the results are legally inadmissible in court. It's a dead end. First, the officer must give written notice of their intention to the occupier. Second, they have to collect the sample right there in the occupier's presence. Third, seal and sign the container alongside them. And fourth, send it immediately to a recognized environmental lab. So say you get an exam question where an inspector secretly sneaks in and takes a water sample at midnight without notice, well, now you know exactly how to attack the legality of that evidence.
Now let's revisit Section 33A of the Water Act. This gives state boards tremendous enforcement teeth. And the best part? They don't have to wait around for a lengthy, drawn-out court trial. If a factory is caught dumping untreated waste, the board doesn't just issue a slap-on-the-wrist fine. They can order the immediate closure of the plant, or they can literally call up the local utility and order them to cut the power and water supply right then and there.
Right. Moving to Section 4, Landmark Environmental Judgments and Judicial Interpretation.
You know, the structural mechanics of these boards aren't just administrative red tape. In the landmark case of AP Pollution Control Board v. MV Nayudu, the Supreme Court made it explicitly clear that the fundamental aim here is actually a constitutional-level imperative, ensuring clean drinking water for all citizens. Anchoring your exam arguments with this overarching, profound purpose, it's incredibly effective for boosting your score.
You also have to know how this law is actually litigated in the real world. The Mehta Ganga pollution case, that is your gold standard for the public trust doctrine, proving the state is obligated to protect natural resources. And when it comes to massive industrial disasters and absolute liability, Union Carbide and Sharon Lao Sahu are the absolute definitive citations you need to drop. Okay, Section 5, Exam Synthesis. Let's pull all of this together and tackle a hypothetical scenario.
Consider this 12-mark situational problem pulled straight from a past paper. Picture this. You have tanneries operating right on a riverbank. and they are discharging highly toxic, untreated solid and liquid wastes directly onto the land, which is severely polluting the river. Naturally, the local residents are furious and want this stopped immediately.
So, here is our two-part challenge. What are the specific legal remedies available to those residents, and what direct actions can the State Pollution Control Board take against the defaulting tanneries? Now, to answer this effectively, we can't just write a generic essay about how pollution is bad. We have to walk through the exact step-by-step legal argumentation using the IRAC method: issue, rule, application, and conclusion.
By synthesizing our knowledge, here is your high-yield breakdown. First, the issue. It's the unauthorized discharge of trade effluent polluting a stream. Remember that specific definition we talked about earlier? Next, the rule. This clearly violates Sections 24 and 25 of the Water Act because they are discharging without SPCB consent. Now for the application. While the board could theoretically go to a magistrate, they can act much, much faster using their direct powers under Section 33A. And finally, the conclusion. The SPCB issues a binding direction for the immediate closure of the tannery and orders the utility to completely cut their power and water. Bam! Full marks.
So, as you review your notes tonight, it's really easy to just view these laws as a dry list of rules and definitions. But consider this for a second. If Section 33A gives the State Board such immense, immediate power to shut down polluting industries without even needing a trial, why do major rivers like the Ganges still struggle so heavily with toxic trade effluent today? Is the issue a lack of a legal framework, or is it a failure of actual enforcement? Think deeply about that as you master this material. Good luck with your exam prep.